Next case is Sejasmi Industry versus A Plus Mold.
It's fair. As soon as it's my fault. I accept full responsibility. Yeah, this.
In addition to the two parties here, it's my understanding that the Amicus American Mold Builders Association will have 5 minutes. Is that correct?
Yes.
Okay.
Yes, Your Honor.
Thank you. Please proceed.
Good morning, Your Honours. My name is Daniel Broxup, and I'm appearing on behalf of the appellant Quality Cavity, Inc. May it please the Court, this case involves or deals with the situations in which a mold builder's lien can be extinguished, and specifically it deals with Section 9, subsection B5, which says that a mold builder lien can be extinguished if the molder sends a verified statement to the customer stating that the molder has paid, quote, the amount for which the lien has been claimed. Now that language in the passive voice led the lower courts to question whether or not the statement required under Section 5B has to state whether or not the mold builder has been paid, or whether it can simply state that anyone has been paid. And the lower courts both opted for the latter of those options. But I think a simple example will illustrate why that was clearly erroneous. Assume the situation where the mold builder claims a lien for $100 on a mold. A purchaser comes along and pays $100 to the molder, not to the mold builder, but to the molder. Nothing further happens. Prior to the transaction, the amount of the lien was $100. Subsequent to the transaction, the amount of the lien was $100. There's been no change in the amount of the lien, and therefore it would be incorrect to say that the amount of the lien has been paid. This position also finds support in subsection 3 of Section 9, and this was addressed by the dissent in the Court of Appeals by Judge Hoekstra, and that provision specifically defines the amount of the lien as the amount that's owed to the mold builder. And so if you read subsections 3 and 5B in conjunction, as Judge Hoekstra pointed out in his dissent, the inescapable conclusion is that the notice required under 5B has to indicate that payment has been made to the lien holder, to the mold builder. There is further support for this position in subsection 2. Subsection 2 addresses or requires a mold builder to file a UCC1 financing statement as part of the requirements for perfecting its lien. And this puts the world on notice, this is constructive notice to the world, that not only is somebody claiming a lien, but the identity of that lien holder. And the identity is important because whenever you're dealing with...
Counselor, good morning. Welcome to the court, and I just have a question for you. This seemed very dramatic in terms of the materials that were submitted, that ultimately this could threaten the entire industry. Can you explain, we've never had a case like this before, so it's kind of the first kind. Can you explain, why this is so intense, why this is so dramatic, and why, ultimately, based on the writings and the materials that were submitted, this could really put the entire industry in peril?
Yes, so prior to 2002, mold builders had to make do with artisans liens, which are possessory liens. And the problem with that was that mold builders either had to be paid everything up front, or they were at substantial risk that they weren't going to get paid whatever they were still owed at the time they relinquished possession. So 2002, the Act was amended to add the mold builder lien, and that's a non-possessory lien. And so now the mold builder has the security to be able to relinquish possession of the mold and still have the security that they have a lien that's attached to the mold. Now the rulings of the lower courts here will make the situation, won't turn it all the way back to how it was prior to 2002, but it takes away a lot of the security of the mold builder. The mold builder now, if they release that possession of the mold, they can only be sure that they have a lien until something completely out of their control happens, which is the molder sending a statement saying that they've paid somebody. So the insecurity that the mold builder has...
How often is someone just going to pay somebody? Like that's kind of where I was kind of caught off guard with this. Help me to, I just want you to educate me, help me understand. When would I write a check just to anybody? I mean, I'm going to write a check to the necessary party. In this case, wouldn't it be Takumi, I believe? Isn't this really a situation where it's a fight with the subcontractor? Not the bill was paid. It was just the payment that was rendered wasn't passed on to the mold paper, so it wasn't passed on to your client. So I guess the question is, so if I'm in this industry, I mean, can I have to make the same payment twice?
Yeah, that's how liens work in every single instance except for one, which the legislature has specifically by statute said that residential homeowners, they can pay a general contractor and not be on the hook for any unpaid amounts that the general doesn't pay to the
So
sub.
if I'm a company and I hire a contractor, I need to then go, why would I even pay them? Why wouldn't I just pay directly to you? I mean, that just seems like, so if I'm sending a check and I send a check to the contractor and the contractor doesn't pay it, I'm still on the hook. Why would you even, that just seems like a pretty big responsibility for one of the parties, that basically they could pay their bill and then they're still on the hook if that bill isn't paid through the second party.
Well, that's, again, how liens work.
Okay. I understand. No, I understand. If you just go on, I understand. But you understand my reservation with that.
The point I want to make is that it's not that big a burden. That's why you have a UCC filing system. The molder, and in this case, or the customer, in this case Sejasmi, has the burden of going to the UCC filing system, seeing if there's a lien on the mold. If there's a lien on the mold, they find out who has the lien, and they don't purchase the mold until they've discharged the lien. It's the same as if you went to a mortgage to purchase a home. If you go to the closing to purchase a home and you pay somebody other than the seller's mortgage holder, you're going to have a problem. You're going to have to pay twice if the seller absconds or goes bankrupt. And that's how every single lien works. The burden is on the purchaser. And as I said, there's one instance in Michigan where that was upended, but very specific and explicit language was used in the Construction Lien Act to turn that on its head.
So that's how the molder protects itself from having to pay double here. So Sejasmi protects itself by determining whether there's an outstanding lien, and if there's an outstanding lien, it may choose not to do business with the molder. Is that right?
It inserts on a discharge of the lien before the lien's paid, and if there's no discharge of the lien, then they're not going to pay.
That's exactly right. I mean, the customer or the molder has options. They can say, look, we're not going to make the payment directly to you, Takumi, even though we have privative contract. We're going to send that check directly to Quality Cavity because we know they have a lien. They have a mold builder lien. They can protect themselves, and that's precisely what the UCC filing system is there for. It's there to put the burden on the purchaser, and as long as, in this case, the mold builder...
Well, the first burden goes on the person who has to file the lien.
Correct, yes, and there's several steps that have to be followed to file the lien.
And that's why they're all governed by statute. There's this mess out there that the legislature chose to address, that there's all these parties in line and we want to make sure everybody gets paid. So they made a lien system. First, it puts the first burden on the party to file a lien, and then it puts another burden on the party at the end who's making payment to make sure the liens are satisfied.
That's exactly right.
And it's not just molds, it's across the board. There are all sorts of liens like this.
Yep. Every single lien, as I said, operates this way, and that's exactly right.
Of all the lien statutes, are there any that lets the person off under this circumstance?
Only the Construction Lien Act, as I was mentioning before, and they specifically say in the Construction Lien Act that the residential homeowner can pay the general contractor, and as long as he files an affidavit with the court, he will not be at risk of any claims from the subcontractor. And that's a very unique provision in lien law. I mean, it literally turns it on its head. And the legislature, in enacting that, was very, very explicit. It says you may pay the contractor and not be at risk of any claims from the subs. There's nothing even close to that in the mold lien statute.
Do all these protections work the same way in what I think is the more typical situation where the customer is doing business directly with the molder instead of the mold builder?
They would work in the same way. In that instance, the payment, presumably there would be privity of contract between the customer and the mold builder, and so they would have various options. They could file to sue on the contract, but they would have a lien. I think the typical situation, is where you have an OEM or a Tier 1 supplier will be the customer. And then you have a molder, and GM or Magna in this case will buy a mold and they'll give it to a molder to house in their place, and they'll produce plastic parts. But it's the mold builder that has built that mold. And so oftentimes that customer will not have direct contact with the mold builder. All of their contact will be with the molder. And that's why subsections A and B are very important, because you have to look at those from the perspective of the customer. Subsection A, it deals with a situation where, what it says specifically is that actual payment to the mold builder satisfies the lien, which is standard and normal. That deals with the situation where the mold builder is in contact, where the customer is in contact with the mold builder. Subsection B addresses a different situation where they're not in communication. That addresses the situation where the customer is communicating with the mold builder and has no relationship is communicating with the molder and has no relationship with the molder. In that instance, the customer needs to be sure that the lien has been satisfied. And because it doesn't have communication with the mold builder, what happens is the customer will go to the molder and say, okay, can you give me a verified statement saying that you paid the mold builder? So when they don't have contact, the customer can rely on the word of the molder that the molder has paid the mold builder.
That makes sense, but what do we do with the fact that the actual language says the customer receives a verified statement from the molder that the molder has paid the amount, not that the molder has paid the mold builder? Don't we need to read in a few extra words here to have it work the way you're telling us it should work?
I don't think you do, because as the example I was illustrating earlier, prior to the transaction, the lien's going to be $100. If you don't pay the lien holder, the amount of the lien subsequent to the transaction is still going to be $100. So the amount of the lien has not changed. The amount of the lien has not been paid unless it's paid to the mold builder. But again, there's a definition in subsection 3 that defines the amount of the lien as the amount that is owed to the mold builder. And so you have to look at the entire context, not myopically focus on one section. You have to look at the purpose of the statute, which is to protect mold builders, and you have to look at the context that surrounds this provision. And it literally would make no sense to have, what happened in this case, to have Sejasmi send a verified statement to Takumi saying, Takumi, we paid you. It serves no purpose whatsoever.
But Justice McCormick is correct, though, that you are inserting the words owed to the mold builder in B after amount. But I don't know that doesn't have some logic or some rationality to it, given that the entire statute concerns mold builders' liens.
Yeah,
but
talks about
it is correct that you're reading language into it, though.
Well, the amount for which the lien is claimed, and there's only one person who's claiming that lien, it's the mold builder. Again, I think you have to look at the context. And this is a court that looks at the entire statute and the purpose of the statute. And if you myopically focus on those few words and the use of the passive voice, you're going to run into a situation where clearly you're not following the intent of the legislature.
But you're actually reading words into A2 when you say at the end, following customer or molder to the mold builder. In other words,
But the argument is that the purpose of the statute supports that read-in, I guess. That's just not, this
Yeah.
court doesn't usually do business that way in looking at the purpose over the language, so it's a,
I think it would be clearer if it had said that, but
Yeah.
just because it's unclear doesn't mean it's ambiguous. There's only one reasonable interpretation of that provision. And the other thing I would say is you have two options. Either it means you have that the notice has to say that the mold builder is paid, or it means that the notice can say anybody in the world has been paid. So you have to read something in, and if you're going to read anything in, it should be mold builder.
okay. Any further questions? Okay. Thank you, Counsel.
Thank you.
Well, let's go with you now, if we can do that, okay? And we'll have the association represented at the end, okay?
If he makes any arguments, he'll get a chance to respond.
Thank you, and may it
Okay,
please the
well, I'm
court.
sorry, my colleague makes a good point. Maybe it would be a more logical sequence if we heard from the other side and you had a chance.
I would hate for him to
respond.
raise something and then you not have the opportunity to respond.
That makes perfect sense.
Justice Zarr makes a good point. Okay.
I think that makes sense as well.
It's unanimous.
Good morning. Gaten Javillarash on behalf of the American Mold Builders Association and 17 other tool and die industry amici. Thank you for giving us 5 minutes to address the court. May it please the court. I would like to start by addressing Justice Bernstein's question. While I think that we were certainly referring to an absurd situation where you would pay anyone, perhaps including your mother, as counsel pointed out, there's really the only two options. Either the statute allows you to pay anyone, including your mother, or it requires you to pay the mold builder. It doesn't limit it in any other way. And also to the question of, well, the purpose of the statute, right? This is a contextual court, and when it comes to statutory interpretation, it is proper to consider the purposes of the statute. And from the industry's perspective, if the Court of Appeals interpretation stands, or this court adopts it, it will be as if the Lien Act did not exist in most situations.
but wait a minute, it's an unpublished Court of Appeals opinion, right? I mean, it's not, help me with why the sky is falling exactly. If we never got involved in this, your brief was really helpful. It taught me how complicated the economics of this industry are, and that then taught me that the legislature is the body designed to figure out those economics and figure out how to manage them in a statute, right? And for some reason, it didn't put in sub 2 or B or A or whatever we're calling it, to the mold builder. And I don't know if that was because after listening to the testimony and thinking carefully about the economics of the industry, it decided we want to make sure I get the terms wrong, the molder doesn't pay twice, right? Maybe that's what the legislature was worried about when they chose those. And I'm a court, I don't get to take that testimony and figure out how to best protect the different players in this really important industry. Why we have an unpublished Court of Appeals opinion? Why don't you guys go over across the mall and tell the legislature they forgot 3 words and fix it?
I'm glad you asked that question.
Thank you.
Here's what's going to happen. Now that you, under the Court of Appeals decision, and I recognize it's unpublished, but that's the only decision out there right now, and that's what everyone is going to follow. Under that decision, if all I have to do is find my own Takumi or create my own, a subsidiary, for the purpose of procuring molds, dies, and tools, pay that entity for the mold, tool, or die, and then certify that entity I paid you the full amount, and there is no more lien. And the manufacturing industry that uses mold, tools, and dies, especially the automotive industry, is well lawyered and highly sophisticated at supply chain management. There's no reason why they wouldn't do this every time. And in fact, I'm sure that they will be advised to do so. And so, as a practical matter, this loophole that the Court of Appeals believes exists in the statute will swallow the entire statute. It won't, as a practical matter anymore whether you put a lien on it or not, because everyone up in the supply chain is going to use an intermediary subsidiary like Takumi might be their own subsidiary. It's not unheard of for OEMs and Tier 1 suppliers to create a sub-entity specifically for the purpose of procuring parts. And that's exactly what is going to happen here. And we will be back to where we were in 2002 before the Lien Act was ever enacted, because the only way for the mold builder at that point to protect itself is going to be either hold on to the mold or sue under contract. This Lien Act was supposed to avoid that situation. I do think, however,
that convincing and compelling, but it seems like the kind of thing that you would tell a legislature who would like then listen to whatever arguments there were on the other side and manage it. Like I'm not a mold lien economist.
That's true, but
I
the
might
court,
be in my next career, but I'm not yet.
the court has to interpret the statute, and I understand that the purpose of the statute should never override the statutory text. But when the statute's unclear, and which is the situation you have here,
Or ambiguous.
it's completely appropriate to look at the purpose of the statute.
You're saying it would not be a reasonable interpretation that you could pay your mother and satisfy the lien.
Correct, but that's the interpretation the Court of Appeals has given. This court has said that to ascertain the goal in statutory interpretation, I'm sorry, I see my time is up. May I finish what I was going to say? The goal in statutory interpretation is to ascertain the legislative intent that, quote, may be reasonably inferred from the statutory language. And that was cited in the Court of Appeals majority opinion. We submit that the reading of the statute as a whole and in light of its purpose, the only reasonable interpretation is that you have to certify that you paid the amount for which the lien is claimed by paying the person who claims the lien, and that is the mold builder.
Counsel, can I ask you one question, please? Is there any evidence of any informal or formal standard or practice in this industry that's developed since 2002 that Sejasmi, in your view, either overlooked or ignored in some way? In other words, what has been the way of dealing with this kind of situation over the course of the past generation? We don't have much case law, do we?
Well,
there's no case law that
there's
provided any guidance until the lower court issued its decision.
Correct, and I think it's anyone's guess as to why this sort of case hasn't come up before. I think that's
What should Sejasmi have done different other than trying to scrutinize the mold building statute more carefully and reaching the conclusion that you would subscribe to?
When it received a mold that had Quality Cavity's name on it, it should have looked at the financing statement to see if there was a lien. And if there was a lien, then Takumi did not fulfill its obligation under the contract to supply a mold free and clear to Quality Cavity, and it doesn't have to pay Takumi until that happens, and they can come up to an arrangement where Quality Cavity sends at least part of the payment that's owed to Quality Cavity. Sejasmi can send the part of the payment that's owed to Quality Cavity to Quality Cavity.
But I understand I'm asking questions somewhat external to the four corners of the statute here, but is that in fact, in your view, and is there evidence in support of your view, that that's what mold builders and molders and customers would have done over the years since the Act was enacted early in this century?
I think the more common scenario has not been one where there was an intermediary. Usually it was the molder directly to the mold builder. I don't want to represent that I have any evidence about how the situation's been handled ordinarily where there is an intermediary.
So it's arguably just Sejasmi's bad luck here that in this case the molder who was doing business directly with the mold builder either become bankrupt or otherwise unable to pay what it owed to Quality.
I would say it's not just bad luck, it's a failure to protect itself by looking at the financing statement to see if the lien had been released.
Okay. Thank you very much.
May it please the court, my name is Scott Erskine and I'm here for Sejasmi. The good news, Justice Bernstein and Justice McCormick, is the sky's not falling. This is a somewhat unique situation, as is referenced in appellant's brief at page 7. they write that the customers who purchase molds from QCI are typically suppliers who use molds to produce plastic parts, molders. So mold builders usually contract with molders. That's the typical situation. If we had the typical situation, the majority situation, we wouldn't be here because there's no dispute that my client paid over $387,000 pursuant to a contract that it had with Takumi and completely performed under the contract to obtain the molds. The brief of appellant goes on to say, occasionally the customer is a supplier who sells the mold to a molder or a middleman. The instant case involves the latter situation. That is what we have here. And the problem that appellant has is that the statute is absolutely clear. It's absolutely unambiguous. In fact, at the trial court level, appellant argued that the statute was clear and unambiguous. And nowhere in it does it say, Section 5, subsection B, does it say the words "to the mold builder"? Because that's not the situation we have here. This subsection B is the only protection that my client has as the molder in this statute. If you read in the words, if this court is to read in the words "to the mold builder" in subsection B, then we'll get rid of subsection B. Because subsection A, if the mold builder, or if the molder sends a verified statement to the customer that it paid the mold builder in full, well, that doesn't need subsection B. Because subsection A, the mold builder has paid the amount owed by the customer or molder. Why do we need subsection B?
How does the customer know, though, that it was paid?
What's that?
How does the customer know that the molder was paid, or that the mold builder was paid by the molder?
It doesn't, that doesn't help the customer know that it's paid, but the subsection B isn't just an informative passage for the customer. It's one of the ways to extinguish a lien.
Well, it says the customer receives verified statement. That seems to me pretty informative to the customer.
Right, and I believe that this section is exactly designed for this situation where the molder is paying the customer and the customer then has to pay the mold builder. So that these are complicated transactions. There are POs, there are wire transfers, there are ACH payments, checks going back and forth. And so when the molder has paid for the equipment, it can tell the customer who has a contract with the mold builder, we've now fully paid, to put them on notice that if they are holding back any payments to the mold builder, they should release those funds.
If the molder pays the customer,
yes,
under subsection B,
yes,
the molder also has to provide the customer
yes,
with its payment, the verified statement.
yes, with a verified statement. That's correct. And in this case, that's exactly what we did, and it's attached as Exhibit 11 to appellant's brief.
And in that way, they can then give it to the mold builder?
And that way, any payments that they haven't paid, that they haven't remitted to the mold builder, they can do that so that the liens can get released.
So then what's the point of the verified statement that's given under B?
Because these are complicated transactions, there are many checks, wire transfers, so that the molder can show the customer, look, our accounting shows we've paid you every penny for these molds, so that the customer can then go to their mold builder and finish paying the mold builder to get the liens released. If you read it any other way, it's a meaningless paragraph.
Wouldn't it make more sense for the molder to receive the verified statement?
No, because the molder's the one making the payments, so they're the ones that have the interest in making sure that the lien is extinguished.
Well, I understand. They're giving it to the customer.
Correct.
And what you're saying is the customer's got to turn around and pay the mold builder.
Correct.
But the
to any funds that they haven't paid them.
But the mold builder turns around and says, molder, you owe me money.
But in this case, how does the molder, reading it this way would throw contract law in this state on its head. In this case, QCI, the mold builder, voluntarily entered into a contract with its customer, Takumi. It could have demanded payment terms saying, whoever you're shipping this tool to, we know who we're shipping it to because we're putting our thing on it. We want, as part of that contract, to just make themselves bulletproof, the mold builder could have said, we want direct payments from the molder. But instead, they were fine getting their money from Takumi. They had absolutely every right to demand. We entered into the contract first, and Takumi said, we want you to build molds. And we said, okay, we'll
They
enter the
filed the
contract.
lien.
No, there was no lien because there was no, then Takumi went out and subcontracted with QCI
Right.
and said, we want you to build these molds. So the only way, if B reads, if you insert the words to the mold builder, first of all, let's just throw it out because it means the same thing as A, which we're not really supposed to read a statute in a way that causes whole clauses to be surplusage or nugatory. I mean, and that's exactly what this would do. But the only thing we could do is say, yes, we have a contract with you, Takumi, and you say we owe you money, but we're not paying you. Go ahead and sue us for breach of contract because we're going to pay the mold builder. But reading this statute, my client said, this is my protection. This is the only protection. Subsection A doesn't protect a molder in my position. In my client's position. It only protects, my client's not in privity of contract, so it can't do anything to protect itself with respect to the liens, to get them extinguished. Subsection B allows them as long as they pay all their money. And again, there's no hint, no allegation that my client didn't pay in full for these, that they didn't send the verified statement for these, that they didn't do everything that they were asked. They paid in full for these. In fact, they paid $65,000 extra to get the last mold from QCI.
I thought it was their argument that you can do something to protect yourself, namely assess the number on the mold and do due diligence on that and determine, what the legal relationship is with regard to that particular mold.
We can do that, but in this case, and see, the problem is when you have a company like Takumi, they were apparently slow paying QCI because they were in fact paying QCI. Otherwise, the lien would have been, the amount claimed would have been for a lot more. What they're saying is they're still owed $187,000. The molds cost $380-some thousand. So they were slow paying them. Sejasmi had no way to know that when they were remitting the checks for the molds, that Takumi was breaching their contract with QCI and wasn't paying for them. They had no way to know that.
What about the question that, this is how liens work? I mean, that seemed to be the emphasis of Brother Counsel's argument, that this is just how liens work. So ultimately, does it create a standard where basically you have to then go and make sure? I mean, I guess the idea is it better to have a standard in place where you know that if you're in this situation, you've got to go to the mold, the creator of the mold directly to make sure this is done? So if I know that, I guess my question is, would this create a standard or a guideline that's very structured that says basically to the industry that basically says, okay, you know what, if this is a situation, you can't trust a second party, you have to go right to the mold builder directly to find out what the situation is, and that would actually create a common practice?
I think that this situation that the best practice for a mold builder is to demand payment directly from the molder, either by contracting with the molder or by writing into its contract with its customer that it receives, that it becomes an intended third-party beneficiary of the contract between the customer and the molder. And that, I think, preserves contract law, and it also preserves the statute without reading phrases into the statute that cause parts of the statute to actually not exist anymore, which is the problem that we have here, that the legislature's words cease to exist if this court adds a phrase to subsection B, because it absolutely becomes meaningless. There's no meaning to subsection B once you add that wording. And it's not an unclear statement by the legislature. It says the customer receives a verified statement from the molder. And here's the thing, and underneath all of this is it has to be true. The molder can't just simply fabricate a verified statement saying we paid And that's actually fraud. So they committed a tort by doing
Counsel,
it.
if the court,
Sorry.
no, you go first.
Well, I was going to say, but what about what about to counsel's point that the verified statement could be we paid my mom, or we paid.
Well, in this case, we
Or
attached we attached who we paid it to, and again, that would be fraud. If you just simply said I paid my mom or I paid my dog, that's fraud. I mean, because that's not the intent of contract. So I think they're going down a road that gets a little ridiculous. In this case, we paid we sent a verified statement that we paid the party that we had a contract with. And if we can't pay the party that we have a contract with, then why do we have a contract? And if we start inserting clauses which make them nugatory, how does my client read this and protect itself at all? It can't. The statute's clear. And the Court of Appeals, the majority opinion was right.
If the Court of Appeals opinion were to stand, would this create ambiguity?
No. I don't
Why?
believe it would create ambiguity at all.
Does it kind of create, you're not exactly sure who's responsible or what's responsible? I mean, I guess this court likes to establish clear lines. And ultimately, if the Court of Appeals opinion were to stand, would it be understandable, and would there be consistency throughout the industry?
Yeah, I believe it would be understandable, and there would be consistency, because I think what parties would do would mold builders would want to, as I said before, become third-party beneficiaries or contract directly with the mold builder. And mold builders would also want the same thing, knowing that, yeah, they could rely on subsection B, but it'd be much safer to go with subsection A and make sure themselves, because trust me, my client doesn't like to be in this position where it's paid completely and it's dragged into a lawsuit for doing everything it was supposed to do under the law. It doesn't like that at all. But here we are. I mean, so, it happens.
Counsel, this is, I'd like to ask you a variant of a question I asked the amicus a few minutes ago. I mean, this is a large and important industry in Michigan, yet I can't recall a single case that we've seen on the court over the past generation, certainly not since the Mold Building Act was enacted. From that, I do not deduce that your interpretation is better than the opposing counsel's interpretation or vice versa, but I do deduce that something is working reasonably well in the industry. There is some pattern and practice or custom that seems to be generally well understood. Is that deduction a fair one? And if it is, do you have any evidence of what that standard of practice has been in your industry over the course of that generation?
That's a good question, Chief Justice, and I can answer it like this. My client has entered into contracts both ways, both where they contract directly with the mold builder, and then the lien is released when they pay the mold builder in full, and they've also contracted with customers who then contract with mold builders, where they then pay the customer in full and the customer pays the mold builder in full. And they haven't had a problem until now under either scenario, and they didn't consider this happening. I don't think Quality Cavity, they were getting some checks from Takumi, thought this was going to happen, and certainly my client never thought this. I don't think either party that's here today thought this would ever happen, because I think both of them had relationships with Takumi, and both QCI and my client were performing in good faith with respect to their contracts with Takumi. The problem is Takumi disappeared. I know they sued, my client initially sued and didn't serve Takumi. QCI at the lower court level served and then dismissed its lawsuit against Takumi. But they're not an ongoing concern any longer.
So is it a fair concern that OEMs will set up a lot of subsidiaries that will disappear, and this is a hole in the statute that...
I represent a lot of OEMs, and if you're asking me if it's a fair concern that my clients, Ford, General Motors, Jaguar, Land Rover, would commit fraud, no. I don't think that's a reasonable concern. I think that they're pretty up. I mean, that's what that would be, setting up a shell company to do that. No, I don't think it's a fair concern that that's going to, be a person that's going to spread through the industry. I can't see that happening.
Are there any further questions for Mr. Erskine? Any further questions for the appellant? Thank you both. The case
Thank
will
you.
be submitted.